Great. So I want to introduce, first of all, our esteemed speaker for this evening, and that is Mihaela Apostol, who is an independent international arbitration lawyer and co-founder and moderator for ArbTech, most importantly. She is a dual qualified lawyer, both as solicitor in England and Wales, and also as an advocate in her native Romania for the last 7 years. Mihaela is also a coordinator for the DLOS Tech channel and of the recently created cross-examination Moot. As you can probably guess, Mihaela is an avid fan of all things tech related and has built up a wealth of expertise in many diverse areas of technology. In relation to this evening's topic, Mihaela flew the ArbTech flag in Paris this summer at Europe's largest Ethereum conference, ETHCC, where she spoke about crypto disputes as well. We are therefore very glad to be able to welcome her again to update us as we come towards the end of a turbulent 2022 and look forward to a potentially equally turbulent 2023 in terms of crypto disputes. As you've probably seen from the title of this evening's webinar, it will be a 2022 roundup, and Mihaela will kind of take us through over the next 40 to 45 minutes some of the statistics about digital asset cases, common causes of action, some of the key legal issues that we're seeing, whether arbitration or litigation is being used as a venue for these disputes, and obviously what the future developments might be and where to watch in the next, or in the year to come, I should say. So thank you very much, Mihaela, and please go ahead and if, as I said, if there are any questions, please put them in the chat, and we're happy to make this as interactive as possible this evening. And with that, Mihaela, please.
Thank you, Sean, for the introduction. I will, for the next 40 minutes or so, cover the highlights of the 22 in the field of crypto asset disputes. I'll begin by mentioning that I'll refer to crypto asset or digital assets as an umbrella term covering everything: tokens, cryptocurrencies, NFTs, virtual land, mainly any new tech assets. I will focus mostly on court cases simply because the information is more accessible compared to arbitration cases. And while in the previous years, there were only a few cases here and there, now we have plenty of court cases involving digital assets. This significant rise in the number of cases is due mainly because of two factors. One of them is the current turmoil in the crypto market, and the other one is having to deal with the litigious fallout from the previous cryptocurrency meltdown in 2019. Firstly, as regards the turmoil in the market, one can say that 2022 has been a tough year for the crypto industry. And there are a lot of headlines describing it as crypto winter, a bloodbath, a crypto crash. So everything is quite dramatic, I would say. And here comes a couple of examples. So, for example, the Bitcoin price has dropped 63% compared to the years, and the overall cryptocurrency market capitalization has lost over 1.63 trillion in value. Another study from the Bank of International Settlements conducted between 2015 and 2022 estimated that around 73 to 81% of the people who invested in Bitcoin, they were likely to lose money on their investment in cryptocurrency. And I think I have a slide here. If you can help me, Sean, with the statistics, and yes, here you go. So this is the report from the Bank of International Settlements showing how much money people lost in the last years when it comes to crypto. The consequences were like a domino. Whenever an actor falls, takes another with them, and this increased the impact in the market. And moreover, let's not forget that crypto is highly volatile, and here, a single tweet can change it, can change everything. And all this unsettling matters have an impact on court cases. So when it comes to statistics and digital asset cases, if you were to compare what happened in the last years, we see a significant increase in 2022. We all know that it was, I think, in 28 when Satoshi Nakamoto published a white paper on Bitcoin, proposing a system for electronic transactions without relying on trust, without having the use of intermediaries to perform a cross-border transaction. This, however, evolved so much that the number of and type of digital asset became diversified and expanding significantly over the years. And I have here another graphic with the evolution of cryptocurrencies. I think it's the next slide, if you can help me, where we can see that I think I need your help with the next slide. Maybe we have a technical problem at the moment. It's fine. I can continue to just explain from the graphics that I have that in the last years we have an increased number of digital assets and cryptocurrencies, and in 2022 we have around 10,000 different type of cryptocurrencies, which is a huge amount of new assets floating into the market. And in terms of crypto dispute, around the end of 2019 and 2020, we had the first crypto cases, and most of them appeared in the context of fraudulent transactions, where the courts had to first assess whether digital assets can be considered property and therefore granted protection. In general, those who were sued were companies that created cryptocurrencies or exchange platforms that facilitated their sales, or individuals who promoted them. In 2022, we have a couple of high-profile cases, which include major digital asset providers that faces criminal and civil litigation. And I'll start here with the most recent one, the one that covers all the headlines lately, which is the recent fall of FTX. FTX is the world's second largest cryptocurrency exchange, which recently they filed a bankruptcy in the US because they were not able to meet the customers' withdrawal. There was a concern in the market that one of the FTX related company, Alameda Research, owned crypto in FTX. But the problem was that the FTX employees twisted a bit the code, and therefore Alameda will never be liquidated, no matter what will happen to their investment. And this led to criminal investigation to the founders, and of course those involved in dealing with the platform. Another highlight case is one involving Celsius. Celsius is a major crypto lender, which has been sued for fraud. It is alleged that the crypto lender artificially inflated the price for its own digital coin, and failed to hedge the risk and engage in activities that amounted to fraud. Another example is the case of Voyager Digital, which faces currently a class actions for selling unregistered securities and misleading customers. Another case that made the headlines were the one of Terraform Labs, the creator of the stable coin Terra USD, which is now facing 2 class action lawsuits in the US, and an arrest warrant issue for the founder. So these are just a couple of cases showing that it was not an easy year for those active in the digital active market. But now looking actually to the legal issues, the majority developments come as expected from jurisdiction where there's a significant market for cryptos and NFTs and tokens, etc. And this is the case with, of course, the US and UK, Singapore. There are a couple of cases in Brazil. Brazil has been a great supporter of crypto, and of course from France and Germany. But the majority of data actually comes from the US. And this showed that New York and California are usually the go-to jurisdiction for crypto litigation. And of course, it makes sense. We know about the Silicon Valley. It makes sense that they will go to the nearby court in California. But interestingly, earlier cases were more dispersed across jurisdiction. So for instance, in 2017, 50% of the crypto-related cases were filed in New York and California courts. But then this percentage raised so much that now we have 90% of these litigations in New York and California. So they basically take ownership of everything that's happening in the crypto litigation world. In terms of cases in the US overall, it is estimated that as of May 2020, more than 200 individuals and class action lawsuits have been filed. And this is 50% more since it was in 2020, for example. And by way of comparison, in 2008 alone, during the high financial crisis, there were close to 560 cases, including federal security class actions. We can see that the majority of cases in court decisions come from the US. Therefore, it's mostly a common law dominated approach in the crypto asset disputes. But even if it's a common law approach, we can see that it's not a uniform approach, and I'll make some mentions here and there where the courts have reached different opinions on the same issue. I'll briefly talk about the most common causes of action. I'm not sure if the PowerPoint it's working. If not, I can continue. It's working. Can we switch to the next one? It doesn't look on my screen, but it's fine. I'm happy to continue.
Apologies, Mihaela. Let me reshare it.
I think it's all right if it's not working. I did not have a lot of text on the slides. It was just something to help people follow the presentation, and eventually we can also publish it on our link. So I'm fine without it.
Apologies, Mihaela. My Zoom died.
Okay, no worries. No, I'm just saying that eventually we can go without the presentation.
Great, that should work, hopefully.
Yeah, yes. We are now at the most common causes of action.
Perfect. Here, yes, great.
So based on the majority of cases that have been registered and surfaced this year, we see there are a couple of most common causes of action, and these are either by failure to perform a contract involving crypto assets, or ownership disputes, property rights, recovery of assets that are held on decentralized platform. Of course, IP rights, and here mostly in relation to NFTs, or of course, another example is trademark infringement. A big chunk of the US cases involve the issue of potential classification of NFTs and crypto as securities. And here are regulatory infractions started by the US Security and Exchange Commission or the Commodity Future and Trading Commissions. And they have actually a huge list of cases at the moment. Another big chunk of cases are those involving fraud, money laundering, insider trading information, Ponzi schemes, pyramid schemes, full direct transactions. And these are the type of transaction where someone is advertising that they will create a specific digital asset. They start raising for funding for it. They obtain the funding from the investors, and then they just disappear in 10 years. Another type of action, very common, is negligence and unfair business practices, and of course, bankruptcies and tax cases. Basically, we see here a wide variety of cases, but now I think it's better to focus a bit on the key issue that are decided by the courts. And here again, we have a great variety. Most of the cases continue the trend from the previous years, where the main issue before the courts were either if crypto or an NFT can be considered property. And here there was a whole range of property injunctions, disclosure orders against third parties, worldwide freezing orders, or even orders made against a person unknown. And since there are so many cases, what I did, I selected a few, which in my view address some novel issues compared to the previous years. One of the most important cases when it comes to what's happening in the US is whether or not, and under which condition, a crypto can be considered a security. Yes, crypto is proceeds of a crime, exactly. And the first one I'll focus my attention is the case of LBRY case. Here, the United States District Court of New Hampshire granted the SEC, the Security and Exchange Commission, a motion for summary judgment in a suit against LBRY, which is a blockchain-based video sharing platform. The court held that their coins, the LBC, they have their own coin, LBC, was actually a sold security, which had to be registered with the SEC. The platform granted the owners of the coin the possibility to publish content on the platform, to buy paywall content, and even compensating miners that supported the network. Unlike tokens that were launched to an ICO, to initial coin offering, LBC were sold directly, so there was no initial coin offering for this type of coin. And when they sold the coin, they also kept a couple of those coins for themselves, which was an important factor later on taken into account by the court. The SEC alleged that LBRY undertook an offering and sale of securities under the federal securities law without filing a registration statement for the offer and sale of those securities. And by failing to do that, they denied the investors the possibility to know more about the company and do their own due diligence. In order for the court to decide if the coin was a security or not, they follow what is called in the US the Howey test. Howey is a case from 1946. I can put it later in the chat, where it's established under which condition, under the US law, a contract can be considered an investment contract. And in this case, the court established four main criteria. The first is whether is there an investment of money, whether it involves a common enterprise, whether it's made with the expectation of profit, and whether that profit can be derived from the efforts of others. In the LBRE case, only the third element was in dispute, so all the other things were accepted by the parties. Therefore, the court decided that certain statements made by the companies actually qualified the contract as an investment contract, and therefore the coin is considered a security. So I'll just give a couple of examples. In a blog post following a large increase in the LBC market cap, the LBRI team stated that the long value proposition of the LBRE is tremendous, but also dependent on our team's satisfying focus on the task at hand, building this thing. So they can't enforce that the profit is dependent on the efforts of others. Another statement made by the company was the following. They said in an email to an investor that if our products has the utility we plan, the credits should appreciate accordingly. So therefore, they enforced the assumption that more profit would follow. The court found that based on this statement, but also on the LBRI decision to reserve a couple of the coins for themselves, that the investors expected that they would to profit from their holdings in the LBC as a result of the LBRI assiduous efforts. So the actions of the company in terms of promoting their coin and also keeping some coins from themselves were endorsement of the fact that those coins are actually a security, an investment on an asset that might increase value in time. And this can be seen as a significant victory of the Security and Exchange Commission because it comes in line with their efforts to enforce various legal action against token providers, and one of them is Ripple. Another case that was very much cited in the last years, and it's also the first time when the federal court has decided that a digital asset without the initial coin offering can be considered a security, because this was one of the allegations used quite often, saying that it's not a security. So you have a question, Sean?
Yes, I was just going to say, circling back to the FTX recent debacle, I think it was yesterday or the day before, we saw the SEC released, I think, the indictment or at least the charges against Sam Bankman-Fried. And as part of that indictment, there was a reference, and we haven't seen, and I think this is what you're alluding to in this whole crypto as security principle, we haven't seen the SEC say outright in a case yet that Ethereum or Bitcoin is definitely not a security, definitely is a security, even though that's unlikely. But we saw in this indictment yesterday, the day before, that they did make a reference to Ethereum and Bitcoin, and I believe Litecoin as well, as they view them as commodities. So I think this is also a kind of evolution in a kind of collateral way. It obviously isn't the main thrust of their case against FTX and against Sam Bankman-Fried, the ex-CEO. But I think we're starting to see that, as you say, we're moving beyond the point of only questioning whether all cryptos are securities or all cryptos aren't securities, and it's much more becoming case specific and looking at, well, have they said or done things in these projects, as you pointed out in the case, where they have promised investors the appreciation of the value of the asset, or other means by which people who buy the assets will get passive income by its increase in value. So I think it's a very interesting evolution, and we're kind of coming out of the early genesis of these cases and really kind of starting to be kind of a mature area of case law in the US, it seems.
Yes, and it's a big chunk of the US cases involving crypto. Most of them involve the SEC and the question of whether or not those assets can be considered a security or a commodity, or depending on the context. And I think the confusion started with the declaration made by the former chair of the SEC in 2018, when he said very bluntly that Bitcoin cannot be considered a currency and cannot be considered a security. So this kind of encouraged the crypto developers to sell crypto in the US. But then in a couple of years later, they changed the person in charge, and they come with a different approach, which of course caused a lot of turmoil in the market. And as you said, I think next year we're going to see a lot of developments in this area, establishing more clearly under which condition a crypto or an FTT can be considered a security. Another interesting case that I came across was coming from Brazil, actually. And here the Justice Court of São Paulo decided that it's possible to seize crypto in debt recovery cases, even if those cases do not involve a crypto dispute. So it was basically a simple asset recovery case, and they wanted to see if they can find more assets of the debtor, and they wanted to check as well their online wallets. So the Justice Court of São Paulo gave a decision in October this year, granting a special request coming from Banco Safra, which I understand is one of the nation's biggest and busiest banks. And the bank had asked the court to let it search the debtor's crypto wallet to see if they had tokens and whether those can be liquidated. And the court held that even if there's no evidence to suggest that the defendant even owns crypto, so was not even sure that he has crypto, this should not be an obstacle for the bank if they wish to carry on such a search. And the court underlined that crypto assets are movable assets with a specific function as a means of payment. Therefore, they have a monetary function and can be seized. And of course, the court also ruled that the bank will cover for all the expenses that will appear, of course, for identifying those assets and valuing those assets. And there's also a similar case coming from the UK, but here there's a seizure of NFTs coming from the British tax authorities, which managed to seize a huge amount of NFTs that valued over 1.4 million of pounds. And in this context, they were conducting an investigation alleging involving offshore companies, shark fraud, and also money laundering. And they traced the individuals involved and the NFTs they had, and managed to seize those. We see now that the courts are becoming more knowledgeable of how to deal with this asset, and even take actions by themselves, by their own initiative, to seize those assets. Another interesting case comes from Germany, and I find it a bit funny, but it's something, because it's something unexpected. I never thought about this issue. So the issue is about whether or not virtual land transaction in either metaverse or another decentralized platform, whether this type of transaction is liable for VAT. So the dispute involved a German landlord, let's call it this way, who bought land in the virtual world of Second Life, which he then subdivided and rented to other users in Second Life. So those users' avatars paid him a certain amount of money, which was actually Linden dollars, the currency of Second Life, for their monthly rent. Then the landlord took the Linden dollars and exchanged them to US dollars, and of course generated some profit. This transaction of exchange from Linden dollars to US dollars actually triggered a notice from the German tax authorities asking him to pay VAT. The German tax office claimed that the renting of the virtual land constituted a taxable digital service, and asked the plaintiff to send the VAT to the tax office. This case went from the lower courts onto the federal tax court, so it was not a clear-cut case. And eventually the federal tax court held that although virtual land has a significant value, this value was limited to a particular online environment. If the virtual world closed down, the virtual land would cease to exist. Therefore, in game activities, or activities that are happening only online, and which are undertaken for hobby purposes, should not have real tax consequences. However, the federal tax court noted that activities beyond the boundaries of virtual world may have real tax consequence, and said that the fact that the landlord performed a taxable transaction when exchanging from Linden dollars to US dollars, that could be subject to a tax liability. But since the Second Life platform is actually established in the US, the court ruled that the transaction is not under the jurisdiction of the Germany courts. So eventually the transaction became tax-free. But I think this example is more to show that simple activities that were considered to be purely online, a game just for fun, actually can lead to some legal liabilities, and it shouldn't be treated so lightly. Another interesting issue that I've seen was whether or not crypto can be used as a security for cost. And this came under the UK courts in the Tulip Trading Limited versus Bitcoin Association case. This case has many other legal aspects. One of them is what is the relationship between a crypto account holder and the platform, whether it's a fiduciary duty or not. It's a more complex case, but I will just focus on the security for cost issue. So Tulip Trading Limited was a company registered by Dr. Craig Wright. Some of you might know he claims to be Satoshi Nakamoto, the inventor of Bitcoin. He claimed that his private key has been hacked, copied and destroyed, and he lost access, and started a legal action against a software developer working on crypto wallets. And he claimed in the proceedings that he's willing to give defendants to security for cost, and proposed the following. He proposed to transfer the value of the security order in Bitcoin to its solicitors, plus a 10% buffer to account for fluctuation of the value. He undertook to instruct his solicitor to provide an undertaking that the Bitcoin will be used to satisfy the court's adverse cost in case there's a unfavorable decision against him, and also undertook to top up that value even more in case there's necessary, given the fluctuation between the pound and the crypto. And the court held that it's not possible to grant security for cost in crypto for the simple reason of the high volatility of the Bitcoin. And this is very interesting to highlight, because there's another case coming from Australia, and this case is from 2020. And here the court actually decided the opposite. So a judge in New South Wales granted claimant permission to use cryptocurrency to satisfy a 20,000 Australian dollars order for security for cost. And the plaintiff acknowledged that he was not ordinary resident in Australia, and also accepted the defendant's application that he provides security for cost. It was kind of a bit straightforward here. There was not much resistance. And the court permitted the plaintiff to use cryptocurrency to satisfy the consequential order for security for cost, despite the defendant's concern of the volatility of these assets. So we see here, even if the crypto litigation is a common law dominated sphere, there's no common approach when it comes to some issues. Another interesting example is the case of OpenSea employee who used the information they had to buy NFTs that were about to be featured on the first page of OpenSea, so the one that will the one that will have more exposure. He will buy this in advance and then make a lot of profit when those NFT will be featured on the first page. And what the employee did was to use anonymous OpenSea accounts, purchase the NFTs, funnel funds he received from selling those to other multiple anonymous Ethereum accounts. So that he did a bit of layering and hiding his asset in order to conceal his involvement in the transaction. And this led to an allegation of money laundering, plus insider transaction, plus insider trading allegation, because he used his own position and information he had to make his own profit. Another interesting case is coming from Singapore, and this is a case that's it's very interesting. It's theoretically simply just an injunction, but it's an injunction in the context of an NFT contract. So in May this year, the Singaporean court issued an injunction freezing the sale of well, I'm not sure, probably you know the Bored Ape Yacht Club NFT. They're kind of well-known NFTs with the monkey. So the injunction said that the platform cannot sell those NFTs, and I'm going to give you a bit more context. So, as part of a dispute between a borrower who took some money and granting those money with the NFTs of a Bored Ape club, he eventually failed to pay the borrower. Sorry, he eventually failed to pay the lender. But importantly, the contract between the borrower and the lender specifically said that the lender is not allowed to sell the NFT to encash his what he gave, and therefore, when the borrower became unable to repay the loan, the defendant, in violation of the contract, transferred the NFT to a personal Ethereum wallet and listed the sale on OpenSea. The court took action and stopped the sale of the NFT as per the parties' contract. So we see here, even if it's just a purely contractual transaction, right? Do someone borrows money, they do not respect the terms of the agreement, but because they guarantee that loan with an NFT, the NFT is tried to be valued on a market, and therefore the borrower managed to have an action and recover the NFT because that was the agreement that under no circumstances they can encash the NFT. So these are just a couple of court cases. There are so many and so diverse. But apart from the legal issue, what gathered my attention was the novel procedure issues. So we have a couple of examples of the court agreeing to serve summon of a new case via an NFT. And this is the case of LCX in the US, but there's also one in the UK during the summer. And the case involved the theft of nearly 8 million worth of assets on Ethereum blockchain. And the attorneys served the defendant with a temporary restraining order in the form of an NFT. The NFT contained a hyperlink to an order to show cause and included a mechanism to track the NFT when it was accessed. So you know exactly when the person took knowledge of the summon. And it was airdropped to the cryptocurrency wallet, which was stored in on the crypto platform. Another novel way of serving comes from the US as well, and this one involves the dispute of OOKDAO. Probably heard about as a dispute about liability of the DAO founders, and in this dispute, by way of a court order in October 2022, the court granted the Commodity Future Trading Commission a motion holding the service of a process to OOKDAO by way of copying the summons and the complaint to the DAO's help chat box. They basically summon them via chat box and also posted the notice on the DAO's online forum. And for the court, that was more than enough to meet the requirements of having knowledge of a case and being served a case. So we have two novel ways of serving a case now, via NFT and via a chat box, a simple chat box. I think I cover a lot in terms of disputes, and I see we have just a couple more minutes. I will just touch briefly in terms of the clash between arbitration and court litigation. And we see here a clash, especially when it comes to consumer disputes involving crypto, because the majority of crypto platforms have an arbitration agreement in the terms of and conditions. And in the US, the validity of those arbitration clauses, it's not one that is straightforward. Those arbitration clauses need to meet further conditions under the US Federal Arbitration Act in order to be valid. And the same issues in the UK as well. There's a case to watch, and it's called Soleimani versus Nifty Getaway. And here the UK court is about to take a decision on the validity of arbitration agreements from consumer disputes. And it'll be very important to watch, because once they take a decision, very likely they will follow the same path. And another important issue is the enforceability of arbitration awards, which have damages expressed in cryptocurrency. So there was a case coming from Greece, actually this year, ruling that the recognition of a US award granting damages in Bitcoin is contrary to the public policy of Greek. And there was a similar award coming from China, I think in 2018. And somehow in China, it kind of makes sense because they have banned crypto. But it's important to be aware of the consequences of having an award of damages expressed in a cryptocurrency, because that might not be recognized by the courts of law, especially in jurisdiction where we're not very crypto friendly. And just to conclude, in terms of developments and things to watch in the future, I think for the next year or next couple of years, we're going to see an increase in collaborations between jurisdictions in terms of enforcing criminal actions involving crypto or digital assets, because of the problem of this type of transaction that go across borders. I've seen a couple of collaboration between Brazil and US, and of course this requires to have a convention between countries, but I think that will become more common in the future, just because it's absolutely necessary. Another trend that I think will increase will be people using a lot of the services of virtual asset tracing providers. There are companies specialized in identifying crypto assets whenever they are transferred from a wallet to another. And this service can prove very valuable, especially in fraud cases, when we see people who have received a link, they clicked on it, and they realize that the money just vanished from the wallet. Another trend that I think we'll see is an increased number of crypto disputes in Latin America. For example, according to a Bloomberg report from this year, Latin America accounted for 2/3 of crypto withdrawal transactions. And I think this will be reflected in the number of litigation cases, especially when it comes to what's happening in El Salvador, Brazil, countries that started to embrace more and more crypto. And I put there on the slides 2 cases to watch. One of them is the SEC versus Ripple. And they will discuss the same issue under which condition a crypto or a digital asset can be considered a security. And another case to watch is the case between CFTC and OKDAO, where they will have to decide under which condition a DAO can be liable, whether the founders can be liable, whether all the participants in the DAO can be liable. They basically now trying to allege that all of them can have liability in case there's a fraud or something happening with the DAO. Yeah, I guess that's all of my end. I think
Great,
we can.
Mihaela. That was an absolutely fulsome look at an overview of all of the things that have happened in 2022, and I think a great way to finish to look at the future developments. This UkiDAO case, actually, I believe the first hearing happened in the last 10 days, and it does seem like the judge in that case is not overly, shall we say, persuaded by the CFTC's arguments about all of the DAO members being personally liable, but we may see some shift in that, and maybe I'm sure it'll be appealed, because the CFTC definitely seemed very, very aggressive on a kind of a regulation by enforcement basis to try and, I suppose, demarcate their jurisdiction and say, this is what we believe good policy is in relation to crypto disputes. So obviously it would not be a great thing if all of the DAO members are found to be personally liable. I think it would kill DAOs for, the foreseeable future, unless we get regulation on such as we see in Wyoming, where it's like an LLC. It has a limited liability structure. But again, as you say, there's a lot of things to watch in the coming years. Perhaps to pick up on James's points and crypto as the proceeds of crime, I think, as you rightly said about this asset tracing, the rise in asset tracing providers, we see people like Chainalysis, and it's even being used as we saw in the past few days in the FTX case, really to show what assets FTX had and where they dispersed those assets to. And really the great thing in some ways about tracing fraud in relation to crypto and digital assets is that blockchain structure allows everything to be very, very transparent and very, very hard to hide. The only weak link in the chain only then becomes, how do you tie certain wallets to certain real world individuals or entities? And so really that's where the kind of investigative asset tracing side really has started to focus. But obviously that is their bread and butter in any case when it comes to traditional, shall we say, investigations. And then in terms of, I see James asked again about crypto as security for costs. I do agree with you, and probably with the court, that where an asset is so volatile, it's unlikely that it's going to be accepted as a security for cost. But we also see stable coins. We see pegged digital assets that have a very stable value, and therefore I think it's only a matter of time until we see a change there in the common law system. And again, we even saw it was an unsuccessful argument yesterday at Sam Bankman-Fried's bail hearing in the Bahamas. His lawyer tried to argue that he could provide or should be able to provide bail in the FTT token, so the FTX's own token, because obviously he has quite a lot of it. Bail was not granted, so I don't know if on what basis the bail wasn't granted, or if it was going to be granted, would it have been granted in the FTT token? But I highly doubt it as well, just because of the volatility of that token. So I think we're really on the frontier of a lot of developments.
And a counter argument to the volatility of it, although I agree with the court, but a counter argument to the volatility of crypto or Bitcoin is that if you were to take the average of volatility of crypto in the last years, or just in the last year, is the same volatility as a pound. But the UK court will never say will not accept the security for cost in pound because it was too volatile this year, and that will never happen. But because of the public conception in general of you cannot rely on Bitcoin, it's all in a shady world, it's very difficult to persuade the court that that might have value, and even that value might increase, right? But yes, it's a lot of things to watch, and definitely will be a very busy year next year, and more novel things. I'm just very curious what will appear from a procedural standpoint. We have seen now the service of court documents via NFT, via chat box. I'm just curious what would be next from a procedural point of view. Let's see.
Yes, I mean, I wonder if we'll see enforcement on the blockchain. I mean, that might be the next major development. We may see some ability for some courts to be able to sign their award on or I suppose have the assets that are in play in the litigation in escrow in essence on the blockchain, and being able to sign a judgment and send assets to the winner or whatever it may be. I think that could be coming down the line.
I think there's some sort of attempt in China. I just came across it. The Chinese courts have started a blockchain stored evidence platform for the courts to use it. Most of the information is Chinese. I tried to translate it. I didn't get too far, and that's why I didn't mention it. But I think in time we'll see more of this in terms of at least when it comes to storing evidence or evidence related to, for example, to IP infringement, because then you need to prove exactly the time when certain event happened, and if you manage to store that in a blockchain, then it becomes very transparent and useful, of course, for the case later. I'm just checking very quickly if I can find. Yes, I found the link to the Chinese platform. I'm going to put it here in case you have more time and want to explore what's the future in terms of blockchain stored evidence in court.
Mihaela, thank you very much, and thank you very much to our audience who joined us late on a Thursday evening, a cold Thursday evening here in the Northern Hemisphere anyway. And thank you very much. We will have a host of varied and diverse topics next year. So please do stay in touch and stay tuned to our social media and our website for future webinars. Thank you very much.
Thank you. Have a nice evening.